Hello and welcome to the second video in a series focusing on contract law in England and Wales. In this video we will be examining the first element in the formation of a valid contract, the offer. By the end of this video, you should hopefully be able to understand what constitutes a valid offer, distinguish between bilateral and unilateral offers, recognise an invitation to treat, and understand the circumstances in which an offer may be terminated or withdrawn. So firstly, what is an offer? Well, in the law of contract, Tritle provides the following definition. An offer is an expression of willingness to contract on specified terms, made with the intention that it is to be binding once accepted by the person to whom it is addressed. This can be distinguished from an expression of willingness to negotiate or an invitation to treat. This is a concept that we will look at later in this video. Essentially, in order for something to amount to an offer, it must be shown that there is an intention by the offeror to be bound by the offer, if it is accepted by the other party. Therefore, the offeror will be bound if his words or conduct are such as to induce a reasonable third-party observer to believe that he intends to be bound, even if in fact he has no such intention. Prominent cases on intention to be bound are Moran and University College Salford and Harvey and Facey. An offer may be made expressly, so orally or in writing, or even by conduct. An offer must be clear and certain, as established in the case of Loftus and Roberts. However, whilst the use of language is important, use of the word offer in and of itself does not necessarily make a statement a valid offer, as seen in the case of Datec Electronic Holdings Limited and United Parcels Service Limited. Now that we understand what constitutes an offer, we need to look further at the types of offer that exist. An offer may be made to a single person or a specified group of persons, known as a bilateral offer. Alternatively, an offer may be even addressed to the world at large, known as a unilateral offer. This is where one party makes an express promise or undertakes a performance without first securing a reciprocal agreement from the other party. This unusual occurrence was examined in the leading case of Carlyle and the Carbolic Smokeball Company. In this case, the defendant company put out an advert in the newspaper that if the carbolic smokeball that it sold failed to cure influenza, buyers would receive a reward of £100. To show how serious that the company was about this statement, the Carbolic Smokeball Company claimed to have deposited £1,000 in the company's bank. Mrs. Carlyle believed this advert and purchased one of the smokeballs. She eventually contracted flu. When Mrs. Carlyle tried to claim this reward, the Carbolic Smokeball Company denied her this sum on various terms. In particular, they argued that the advert was not to be construed as a legally binding offer, and that this was actually an invitation to treat, lacking the true intent of an offer. The Court of Appeal held in this case that the advertisement was in fact a unilateral offer made to the world at large. The court found that here an intention to be bound could be inferred from the Carbolic Smokeball Company's own claim that they had set aside £1,000 in anticipation of this eventuality. Now we understand what constitutes a valid offer and the different types of offers, we need to understand the distinction between an offer and an invitation to treat. An invitation to treat is essentially a communication by which a party itself is inviting another party to make an offer. This is usually where there has been no offer yet, and the parties are more or less in negotiations. This type of invitation or indication of an openness to negotiations does not amount to an offer, as established in the case of Timothy and Simpson. Invitations to treat can be identified by whether the parties remain in negotiations, as seen in Harvey and Facey, as opposed to where there is a clear offer and acceptance, seen in Big and Boyd Gibbons Limited. It is therefore necessary to look at the facts to determine whether an offer has in fact been made or not. Examples of invitations to treat are as follows. Goods on display in shops are not generally offers, but are regarded as invitations to treat. The customer will have to make an offer to purchase the goods, and the trader or seller will then be able to decide whether to accept this offer or not. Prominent cases here are Pharmaceutical Society of Great Britain and Boots Cash Chemists Limited, and also Fisher & Bell. Advertisements are generally invitations to treat, as established in Partridge and Crittenden. However, in some instances an advert can amount to an offer, as seen in Carlyle and the Carbolic Smokeball Company. The request for tenders represents an invitation to treat, and each tender submitted amounts to an offer, unless the request specifies that it will accept the lowest or highest offer. If the request contains such a condition, this will amount to an offer of a unilateral contract, where acceptance takes place on performing the condition as seen in Spencer and Harding. One interesting area for consideration is auctions. The way that auctions interact with offers and invitations to treat is unique. Where an auction takes place with reserve, or in other words, where there is a minimum price in place that a seller would be willing to accept from a buyer, each bid is generally seen as an offer that is only accepted when the auctioneer bangs his hammer, as seen in Payne and Cave. Where the auction takes place without reserve, or in other words, where the item for sale will be sold regardless of price, the auctioneer has made a unilateral offer, which is subsequently accepted by the placing of the highest bid, as seen in Heathcote, Ball and Barry. An advertisement specifying that goods will be sold on a certain date is not a binding offer. This is an openness to negotiations, as considered in Harris and Nickerson. Now that we understand what constitutes a valid offer, and also what differentiates an offer from an invitation to treat, we need to consider the ways in which an offer may be terminated or withdrawn. Firstly, an offer may be terminated by the death of the offeror or the offeree. An offer may also be terminated after a reasonable lapse of time. What amounts to a reasonable period of time will be considered on a case-by-case basis, as seen in Ramsgate Victoria Hotel and Montefiore. Alternatively, where the offer stipulates a time limit within which acceptance must occur, the offer will cease to be open for acceptance when that time limit has expired. An offeror may also revoke an offer at any time before acceptance takes place, as found in Dickinson and Dodds. This may not apply to unilateral offers where acceptance requires full performance, however, as discussed in Errington and Errington Wood. Finally, an offer may be terminated where a counter-offer is made. A counter-offer is where an offeree responds to an offer by making an offer on different terms. This has the effect of destroying the original offer, so that it is no longer open for acceptance by the offeree. This was established in the case of Hyde and Wrench. That concludes the second episode in this series. Remember, if you're interested in learning more about contract law, please feel free to subscribe to this channel and to leave a like on this video to help others to find it as well. Thank you for watching, and I will see you in the next video where we will be discussing the second element of the formation of a valid contract, the acceptance of an offer